Ms. Metcalfe, good evening.
Thank you, Chairman Leach and representatives. I know it's getting late. First off, I want to thank you all for being here and hearing this, and then also wanted to make sure that I thank AGC, who we appreciate the opportunity to sit down with them and work and continue the conversation on this bill. What I've heard, and I think Superintendent Montgomery put it best when he talked about this being a quality of construction issue. And I heard testimony from someone, a contractor representative, saying there are always issues with defects. So I think that that's the issue, is who's going to bear the burden and the cost of these defects. I can tell you, I heard the testimony that this does not apply to residential projects, and I can tell you, looking at the code and the bill as presented, it does. And so I respectfully would disagree with that. There is nothing in the bill that excludes residential that I have seen. And I can tell you, having done represented homeowners here in Austin, I am an attorney here in Austin, and I do residential construction litigation. And Section 16 of the Civil Practice and Remedies Code does apply to those cases. So if there is a clarification that needs to occur, I don't see it currently. Moving on from that, I can tell you many defects, whether it be a commercial project, a public project, or a private home, don't appear or become apparent until years after construction is completed. The gentleman that spoke of his experience with the residential facilities in New Braunfels, I can tell you I've seen much of the same thing here in Austin. We went through a period of drought, and then we had a period of lots of rain, and foundation issues arose. Many of those past 5, 6, 7 years, past 8 years. Those happened because of the climate we were in. It was a stable drought, if you will, and then it changed. And with the clay soils that we have here in a lot of parts of Texas, that affected the foundations. That also affected claims. I've seen a lot more claims for water penetration that occurred. And that, again, was the result of we didn't have a lot of rain for a long period of time, and then we did. And shortening this statute of repose would be detrimental to building owners, whether they be private or public or a residential homeowner. Now, currently, if it's before 10 years, an owner can seek relief from the faulty work. There was a concern that I think attorneys were going out and getting people to make frivolous claims in the 9th year, and that was a problem. And first off, many premises owners are not construction professionals, and so they don't have the knowledge or background to recognize defects. And if they discovered them in the 9th year, that there's a defect, then they shouldn't be precluded from pursuing the investigation and the work done to make that claim. I can tell you the Residential Construction Liability Act already provides a provision to penalize anyone who files a frivolous suit for purposes of any type of shakedown, if you will. They are liable to the defendant for reasonable attorney's fees and court costs. That's in the Residential Construction Liability Act.
Yeah, and Ms. Metcalfe, I do want to just clarify that Chapter 27 does state that where there's any conflict in law, any other Texas statute, Texas law that conflicts with that statute, Chapter 27 governs.
Well, it says...
And there's a very detailed notice and limitations period outlined in Chapter 27 that would conflict with this bill.
Well, and I think that needs to be clear in the bill.
Is that accurate or not?
Well, what Chapter 27 says is that to the extent of a conflict between this chapter and any other law, including the DTPA or common law cause of action, this chapter prevails. To the extent of conflict, to the extent of conflict between this chapter and Title 16, Title 16 prevails. That's 27.002 of the Residential Construction Liability Act.
But we do need to clarify this, because there's that would render, if what you're saying is accurate, that would render, under existing law, all of the notice provisions in Chapter 27 null and void, because those are not outlined in Section 16.
Well, it only if there's a conflict, and I think right now there's no conflict. I still, when I file a Residential Construction Liability Act claim, a lawsuit involving that, there are certain provisions I have to follow under Chapter 27. But for instance, if I'm making an allegation that an engineer did something inappropriate, I have to have a certificate of merit from another engineer that says, here's what happened and here's the problem. So right now, the statutes, I don't believe, are in conflict. They just each require different things.
That might be, I understand what you're saying, and that might be a fact question, because my understanding, my reading of this, and as I consider the two laws and Representative Holland's proposed change, I would say that what he's proposing here is in direct conflict with Chapter 27. I could be wrong about that, but I think that I don't think it's clear.
Well, and I think I would agree that it's not clear, and I think that's certainly something that we could work on.
And I don't believe that it's, Representative Holland can speak to this, but I don't believe it's his intent for this to apply to residential construction defects.
Okay, and we'd be happy to work with y'all to make sure that that is clear.
Okay, and I think that's the point. So.
Okay. What I was going to say, though, is along with that provision I just mentioned, the certificate of merit, that is already in existence for these claims, these construction claims. If you're going to make any type of claim against I believe it's Chapter 150 in the Civil Practice and Remedies Code for the certificate of merit, if you're going to make any claim against an engineer, architect, landscape architect, or surveyor, you have to file a report with the lawsuit, or an affidavit, a sworn document by someone in that licensed or registered profession. So either a licensed engineer or architect or a registered surveyor or a registered landscape architect that then says, here's the defect, here's what happened, here's what went wrong. And that must be filed at the time you file the lawsuit. That's Chapter 150.002. So that is already in existence dealing with these construction liability claims. That has to establish the action, error, or omission of the licensed or registered professional. Now, we also have some concerns about the definitions of latent or patent defects. It hinges apparently on, it hinges on what is apparent by a reasonable inspection. And that in itself, I think, raises some questions. What is a reasonable inspection? Is that an inspection by the building owner? Is that an inspection by a professional inspector? And I can tell you most entities that I have represented got an inspection when they purchased the home or the asset, if it's a commercial building, but they don't necessarily go have inspections performed on a yearly basis by a professional inspector. So I think that there's certainly questions about that, about what is meant by this reasonable inspection. As a result, I think what you're going to see is almost a trial within a trial of whether this is latent or patent. I think there's going to be a lot of dispute about these defects as set forward in this. We've got sophisticated construction companies, engineers, and architects that already have significant protections under Texas law. We have folks who may buy an office building where they want to house their small office. We have school districts. We have other things that are not as sophisticated in these ventures of recognizing defects. I think that this bill unnecessarily burdens property owners when they're looking at this defect. I did want to end on a final note. I have done the count, and while there are 22 states that have a shorter statute of repose, 29, and yes, that equals 51 because D.C. is included, 29 have 10 years or longer. And that does include a couple of our neighbors, New Mexico and Oklahoma. Any questions?
Members, any questions? Okay, thank you. Thank you, Ms.
All right.
Metcalfe. Appreciate the
Thank you,
testimony.
Chairman Lynch.